Thank you very much, Mr. Chairman. Thank you, members of Congress. I apologize that I was not able to share with you my prepared remarks, long remarks. I'm even amazed that I was able to get the one-page outline cleared by the Publication Review Board at the CIA. So I'll even summarize my outline here. I'm also sorry, Mr. Chairman, that the committee was not able to have a representative from the Department of Justice at this hearing, as you noted. I think it's clear that as a former prosecutor, I'm not speaking for the department, I'm not speaking for the agency. I think it's also clear that my stock does not rise with my colleagues from the Justice Department or the CIA by being here, but I welcome your invitation to speak to these very important issues. It is much easier for us as former officials to talk about the CIA detention and interrogation program since September 6, 2006. That's an important date because for the first time the President acknowledged what the American public knew, what members of Congress knew, that we had a secret detention and interrogation program. That became clear. Then the debate was going to be on the details of the program, the type of oversight that we would have. What I'd like to do with my few minutes is to make some general observations about this program and then to go very specifically to your question about the destruction of the CIA tapes. I'm fortunate that I was out of the agency during much of this relevant period so I can comment in the way that Professor Saltzburg has as an informed observer of these events, and I'd share these observations with you all. I agree with the committee's work that it will serve the American people to have more transparency, more openness on what kind of interrogation techniques the CIA is using, the Department of Defense is using, and our law enforcement people are using. The administration, to counter, says that if we're too explicit, the terrorists, the bad guys, will train in counter-interrogation. They'll prepare themselves for whatever is in store. And I'm not saying that this is a frivolous argument, but I believe strongly on balance that it makes more sense for the American public and for support overseas to be a bit more transparent, and more transparent than we are today after the Military Commissions Act, after the President's executive order, part of which is classified. Congress can be explicit. If it doesn't like a technique, such as waterboarding, it can ban it. If it doesn't like sleep deprivation, it can ban it. And I commend any work in that direction to be more open about what is on the table and what is off the table. I'd also like us to be sympathetic, though, to the CIA, and we speak broadly about an agency, that this department learned the lessons of Church Committee hearings and the lessons of Iran-Contra. And there are two broad lessons. One, to do anything that is aggressive or controversial, there must be presidential authorization. And two, even if you have authorization, it is not sufficient because the President cannot authorize us to break the law. What many of my colleagues believe is that they accomplished both those tasks. According to the press, we had a comprehensive finding by the President soon after 9/11 for very aggressive actions against al-Qaeda and other terrorists, so that there was a presidential finding. Similarly, we have reportings that there was a lot of lawyering from the Justice Department and the CIA on the specific techniques or specific aspects of the program. You and I may disagree on the quality of that analysis, but if you're looking at it from the perspective of a CIA officer who is not a lawyer, that person may shrug and say, what else could we have done? We had a presidential finding. We also had advice from the lawyers. We're trying to comply with the law. I agree with you that the destruction of the tapes is different and much more alarming for the reasons that you identified. It's become fashionable now for Democrats and Republicans to talk about a national security court, a FISA-type court to sort out these interrogation issues of what is allowed, what's not, to have oversight from an additional branch of government. I support those ideas. I also plug people from the Midwest that we had come up with some of these ideas even before it was fashionable for professors at Georgetown or Harvard. And if you look at a 2006 National Law Journal article written by yours truly, you'll see that someone was thinking about this as a way to balance these legitimate interests of oversight and allowing the CIA to do what's necessary to protect us. What is the context in 2005? And I'll close my remarks on why this was important, that the tapes were destroyed then. And I agree with Professor Saltzburg that we know the tapes were destroyed. The question is why, and why then? I agree with Professor when he implies that the CIA is a monolith, that it has one brain or one soul. So far, from what we can tell, it was a decision by the head of the clandestine service, Jose Rodriguez, to destroy the tapes in November of '05. What was going on in November of '05? This is after Abu Ghraib and the revelations that occurred in the spring of '04. That was a Department of Defense program and abuses related to their program, but it had an effect on the CIA's program. In this period, we've had legal guidance from the Justice Department, the so-called torture memo of August 2002 that had been withdrawn, that the Justice Department was starting to withdraw or back away from some of the more aggressive guidance that had been given the CIA. It's also very important, another part of the check on the CIA is the media, and this was right around the time that Dana Priest in the Washington Post broke her story about secret prisons in Eastern Europe. She knew the countries, but in the back and forth with the CIA, the Washington Post chose not to identify the countries. The media has reported that some of these interrogations that were on the tapes might have been in those secret facilities, so this would have been of concern to people running that very secret program. We also know at that time, as I'm sure all the members of Congress recall, that Senator McCain was gaining support for the McCain Amendment that was going to restrict permissible interrogation. The McCain Amendment was passed in December of 2005, but it was clear in November that the political lines were changing and that what would have been permissible early in our counterterrorism policies was no longer as likely.
You can finish your thought, please.
And one other, and I'll credit your staff members on this, another development, you mentioned the Hamdan decision that did have an effect on the CIA when Common Article 3 started to affect CIA policies. This is the military commissions. And if we go back to that period, we will see that the Hamdan versus Rumsfeld case had been granted cert by the Supreme Court, and that would have been another concern to Jose Rodriguez and others at the CIA. Thank you very much, Mr. Chairman.